good day everyone. We are going to discuss to you the topics under Chapter 4 entitled The Rules Governing the Imports and Exports of Goods. So in business operation, specifically in international business, the sales of goods are the key transactions. So when we say in domestic scale, this refers to the activities, operations, or events kung saan nag-occur within borders of a single country which focuses on local or international context. Whereas ang aton international scale naman, it is the exchange of goods among different countries through imports and export. So meaning, it involves here the activities, operations, or events kung saan nag-transcend siya within nag-transcend siya national borders encompassing interactions between multiple countries and the global context. So to define what is international sales of goods, so they are performed in the form of export, import, temporary import for re-export, temporary export for re-import, and international sales of goods without importing export procedures at border gates. So when we say temporary import for re-export, meaning this involves bringing goods into a country temporarily with the intention of exporting them for later. For instance, a company may temporarily import machinery for exhibition purposes and send it back to its country of origin. So nga man ginahimo nila ini. So when we say a temporary import for re-export, meaning it is also known as temporary admission or temporary importation. So it is a custom procedure kasi then it allows goods to be bought into a country temporarily without paying duties or taxes. So with the intention of re-exporting them after a specific period of time. So when we say temporary export for import naman, it is the reverse of the previous scenario. So when we say international sales of goods without import-export procedures at border gates, this refers to a sales transaction kung saan din ang goods are sold internationally without passing through formal borders of import and export procedure at border gates. For example is ang digital goods such as ang mga software licenses nga ginasold online kung sa din ang physical movement across border is not involved. So we have here the 10 key clauses of an international sales contract. So first we have the description of goods. So this clause can specify niya exact what is being bought and sold. So the contract would detail the quantity, the model, and the specification of the product na ginbakal ni buyer. And second is the contract price. So this clause gina state niya ang agreed upon price for goods. So the contract would specify the total amount of the buyers kung sa diin agrees to pay for them. Third is the delivery terms kung sa diin gina-outline niya kung paano kung sa diin ang goods will be delivered. Fourth is time of delivery. So this clause sets the deadline kung sano ang goods must be delivered. So the contract might state that the good must be delivered within 30 days of the contract signing date. Depende sa kung ano ang ginagrihan ni buyer kag ni seller. So fifth is the payment condition. Kung saan din dinadetail niya kung paano kag sano ang payment will be made. So for example, the contract might stipulate nga ang buyer will make 30% down payment danay upon signing. And ang remaining 70% will be paid upon the delivery of the goods. Sixth is documents kung sa diin gina-specify niya diri ang mga documents nga need i-provide along with the goods such as ang mga invoices, packing lists, and the certificate of the origins. Seven is the inspection of the goods by the buyer. Kung sa diin gina-allow ang buyer para i-inspect danay ang goods upon the delivery para i-ensure nila if they meet the agreed upon quality and the quantity. Eighth is the retention of the title, meaning this clause states the ownership of the goods remains with the seller until the buyer fulfills certain conditions, such as making full payment. 9 is the force majeure. So this addresses the unforeseen circumstances that may prevent either party from fulfilling the obligations such as ang mga natural disaster, ang aton mga typhoon, earthquake, and consider man diri ang pandemic sa aton nga force majeure. Last is the resolution of disputes. Because at the end, this clause outlines the procedure for resolving any disputes that may arise between the seller and the buyer, such as through negotiation, mediation, and arbitration. So we have here the different sources of law that govern international sales of goods. So first, we have the domestic law, international treaties, and international mercantile customs and usage. So first, we have the domestic law kung saan din a sales contract may be governed simultaneously by the laws of many countries. So a sales of contract we can be influenced by the laws of multiple countries. Kay each country is maiba't iba sila nga national law nga ginasundan. So there are a lot of conflict na matabo. So we have here the conflict of laws on contracts. So first, we have the conflict of laws on contract form. So it is the case kung saan ang laws of different countries comprise different rules on the form of sales contract. So different countries have different rules and about how the sales contracts can be made. So for example is ang ibang country is gina-allow sila to be verbal or based on deeds, while others like there is sa Philippines we are is required nga it must be in a written form. So this means nga ang contract might be valid sa isa ka country but not in another country, but it is depends on how it is written or agreed upon. So examples ng conflict of laws on contract form is nag-enter si Afghanistan into a contract with the Philippines. Kung sa diin si Afghanistan is a country typically nga ginakandak ang iya business using verbal agreements or based on deeds. So while in the Philippines is we are mostly we are in a written form in terms of business agreement of contract. So masulod na diri si conflict of laws on contract of forms kung sa diin iba-iba ang ilang ginasundan nga rules in terms of the form of the sales of contract. So next naman is the conflict of laws on the content of contracts. So it is the case kung sa din ang laws of different countries comprise different rules on the various and complex issues such as ang mga rights and obligations of the parties, principal contact terms, or the application of remedies in the case of breach of contract. So when we say breach of contract, it is occur when one party fails to fulfill obligation as outlined in a legally or abiding agreement without valid legal excuse. So in a conflict of laws on the content of contracts, so various countries have different rules about what should be included in a sales of contract and also the rights and obligation of the parties involved. So ang contracts refers to situation kung sa diin ang legal disputes may arise due to different differences of laws or legal principles governing the formation, the interpretation, and the enforcement of contractual terms in different jurisdictions. So for example is si Corporation X is naka-based siya sa Afghanistan is entering into a contract with the Corporation Y kasi di naka-based siya sa United Kingdom to buy machinery. So ang contract is being negotiated and finalized primarily through email. And includes here the terms about the warranties, liability limits, and the dispute will be resolved. So diri na magasulod ang conflict of laws on the content of contracts kung sa diin naka-state sa contract sang Afghan law, kung sa diin naka-state sa contract ng Afghan law ang ila gamiton, but the problem arise it's because ang Afghanistan and the UK have different legal system. So diri na magasulod ang conflict of laws on the content of contracts because magkaiba ang legal system nga ginasundan ni UK kag ni Afghanistan. So rules of conflict do not directly define the rights and obligation of the parties involved in a transaction, but refer to an applicable law which is not most directly or applied. So the applicable law may be lexicory or the law of another country. So to resolve these conflicts, parties can choose which country's law will be govern their contract. So this typically done by agreeing to a specific national law to apply to the contract. So however, if ang party is wala sila nag-make sang choice, ang applicable law is determined through the rules of conflict, which are guidelines that the court use to select the most appropriate law for the situation. So these rules of conflict can be found in a various regulation, including constitutional provisions, laws on investment, maritime codes, and commercial laws. So some countries even have separate codes specifically for private international law, which govern legal relations between people and the business from different countries. So ultimately, ang applicable law for an international sales of contract can be either the substantive legal provision kung sa din ang minista ang naga-directly govern the rights and obligation of the parties, or the rules of conflicts kung sa din ang minista ang ga-determine kung ano nga national law ang applies nga gina-apply sa context. So next source of law is the international treaty. So conflicts of laws may cause disputes in international sales of goods. So to prevent this, countries often negotiate the adoption of related international treaties in order to unify certain rules aiming governing these actions. So when people or businesses from different country buy and sell things, sometimes there can be disagreement because each country has its own rules about how the sales should work. So para ma-stop ang disagreements from happening, countries often talk and agree on some common rules called international treaties. So these rules kasi din maka-help to make sure that everyone knows what to expect when buying and selling across borders. Kasi din it makes the trade between the country smoother and fairer. So we have here the two types of international treaties. First is we have the treaties to unify the substantive rules, and next is the treaty to unify the rules of conflicts. So we have here the treaties to unify the substantive rules. So it states there that the countries have made agreements or treaties para makahimo sang clear rules on how the international sales of goods should work. So these rules cover things like the contracts, rights, and obligation, and what happens if there's a problem. So over time, there were agreements like ang Vienna Convention 1980 have become more important, and country have stopped following older ones. So Vienna Convention 1980, it is an international treaty sa diin gina-establish niya ang uniform rules for the sales of goods across borders. So sa diin it aims to simplify and harmonize the legal aspect of international trade, providing clarity, predictability for the business engaged in cross-border transaction. So CISG was adopted in Vienna on April 11, 1980, and officially came into effect on January 1, 1980. It was also drafted by the United Nations Commission on International Trade Law, or the CTRAL, in an effort to create a uniform legal documents for substantive rules on the international sales contract. So as of August 1, 2011, the UNCTRAL reported that 77 states have adopted to CISG as estimated. So update now, as of now, we have over 90 countries as signatories, including the major trading nation estimated as of now. So the CISG contains specific provisions on rights and obligations of the seller and the buyers, and also the responsibility of each parties in cases of breach of contracts or others. So next is treaties to unify the rules of conflict. So for certain transactions, the national rules of conflict may differ among the countries. So if there exist different national rules of conflict to resolve the same issue, there might occur the conflict of rules of conflict. So applying the rules of conflict causes considerable difficulties and risks in resolving the conflicts of laws. So it explains here how the conflicts between the countries rules about how the laws should apply in international disputes on the disputes that can cause problems. To solve this, the countries are trying to agree on a common rule through international treaties. So we have here the conflict rules of unification. When we talk about this, we are referring to the efforts to create a consistent and harmonized rules about which laws should apply in the cases of international disputes. So the universal international treaties are agreements between countries that aim to establish common rules for resolving conflicts of laws. However, these treaties have some disadvantages. So first is we have the narrow scope of application. O sa diin, amo ni sa ang treaties have often limited applicability, meaning hindi niya cover ang tanan aspect of international disputes or may apply only sa specific type of transaction. Next is the relatively small of business. So they aren't many universal international treaties on addressing conflict of rules unification. So this means that there are a lot of gaps in legal frameworks for resolving international disputes. So last is the relatively small of contracting parties. Kung sa diin, ang treaties may not have the widespread adoption among countries. Kung sa diin, it leads to an inconsistent and enforcement of the rules. So in response to this limitation, ang European Union or ang aton nga EU has taken specific steps to address the conflict rules unification. So first is the treaties with a special regime is na-closed siya. So the EU initially negotiated with treaties with special regime, which had a limited number of participating countries. These treaties aim to establish unified rules for resolving conflicts of laws within EU member states. So as more comprehensive approach to EU has developed its own legislation known as the secondary law to address the conflict of rules unification. So this legislation is known as the secondary law. It is the regulation and the directives directly applies to all the EU member states. So din gina-ensure niya ang consistent rules and procedure para ma-resolve ang mga international disputes within EU. So in summary, the concept of conflict rules unification involves creating consistent rules for resolving conflicts of laws in international disputes. So we have here the Hague Convention 1995 on the law applicable to international sales of goods. So according to this convention, a sale contract must be in compliance with the law chosen by the involved parties. So ang Hague Convention, it provides the rules for determining the applicable laws in international sales contract. Kung sa diin, it aims to establish the rules for determining the applicable laws in cases where parties to a sales contract are located in different countries. So it grants parties the freedom to choose the governing law. So as of now, it has 8 members countries, including Denmark, Finland, France, Italy, Norway, Sweden, Switzerland, and Nigeria. So in Hague Convention, if there is no agreement on the applicable law, the law of the country where the seller has or his or her office upon received order shall apply. So the following exception are first, if an order is assigned to be performed by a branch of seller, the law where the branch of locates shall apply. For example, there is a multinational company called Kila, so which is naka-headquarter siya sa United States. So si Kila has branch office in Germany. So din, it handles sales and distribution for customers located in Europe. So now let's say that Kila received an order for a bunch of shoes from a customer na naka-based siya sa France. So the order is processed and fulfilled by the German branch office of Kila. So in this scenario, since si Kila has a branch office responsible for fulfilling the order in Germany, so the Hague Convention provision applies. So according to the convention, the law that will govern the sales contract will be the law of the country kung sa diin ang branch office is located. So in our example, since the branch office responsible for fulfilling the order is located siya sa Germany, so the German law will govern the sales of contract between Kila and the customer in France. So this means that any legal issues nga mag-arise from the sales of contracts such as disputes over products, the quality or the delivery terms, it would be resolved according to German law. So another exception naman, so if an order is received by the seller or his or her agent in the buyer's country, the law of the country where the buyer has his or her permanent residence shall apply. This is based on Article 3. So, for example, si Sarah, kung sa diin nag-star siya sa France, nag-decide siya para magbakal siya sang laptop from an online retailer na naka-based siya sa United States. It is called as X Gadget. So gin-place na ni Sarah ang iya order on X Gadget's website and the company processes it from the office in California. So since Sarah placed her order from France, which is amunisang iyang permanent residence, so the Hague Convention provision comes into play. So according to the convention, if the seller X Gadget receives an orders in the buyer's country, which is a country ni Sarah, the law of the buyer's permanent residence apply. So sa aton example, since si Sarah, ang permanent address ni Sarah is nakalocate siya sa France, so the French law will govern the sales contract between her and the ex-gadget. So this means that any legal matter related to the purchase, such as ang warranty claims or disputes over the product defects, it would be resolved according to French law. So we have here the statutory choice of law. So this three convention addresses the aspect of international contract law kung sa diin they serve as different purposes and cover different area. So the Hague International Convention and the United Nations Convention on the Contracts for the International Sales Contracts are also known as ang aton nga Vienna Convention are primarily governed substantive rules for international sales contract. Whereas ang other contract nga the Rome Convention on the law applicable to contractual obligation, it focuses on the conflict of laws issues related to the applicable law for contractual obligations. So ang purpose of this contract, it aims to establish the uniform rules for para makadetermine siya sa applicable law to contractual obligation and international contracts. So it is particularly in the cases kung saan din ang parties belong to different legal jurisdiction. So unlike sa Hague Convention, and the Vienna Convention, kasi din they are primarily governed substantive rules of contracts law, the Rome Convention is focuses on the conflict of laws issue. So it provides the Rome Convention provides criteria para mag-determine ang country's laws so diin ginagovern niya ang contractual obligations that includes the choice of law by the parties and the default rules in the absence of choice. So in simpler terms, ang Rome Convention, it allows to the parties in European countries para maka-choose sila kung ano nga country ang kung ano nga country's law nga will govern the contract. If they don't choose naman, the law of the country of most closely connected to contract will apply. So typically where the main business activity related to the contract is located. So in Rome Convention, it involves here 9 European members, initially including Belgium, Denmark, France, Germany, Ireland, Italy, Luxembourg, the Netherlands, and the UK. So later on, 6 more countries joined, such as Greece, Spain, Portugal, Austria, Finland, and Sweden. So it's widely applied on European countries. So another sources of law is the international mercantile custom usage. So international mercantile custom usage are an important source of law governing sales contracts. So they have been recognized and widely applied to the business global scale. So the intention of mercantile customs and usage usually governs specific issues such as the transfers of risk from the seller to the buyer, the obligation of each party related to transport and insurance of goods, and etc. So when we say international mercantile, it is refers to a commercial activities or the transaction that occurs across national borders or involve parties from different countries. So it encompasses the buying, selling, and exchange of goods or services on international scales. So, ang international mercantile customs and usage, it is referred to the established practices and norms within international business community kung saan ginagovern niya ang various aspect of commercial transaction including ang sales contract. So, these customs and usage are they are widely recognized and applied in a global scale, providing standard practices for businesses engaged in international trades. So, example, there is ang mga Incoterms or the international commercial terms kung sa diin nga it will be discussed further by the next reporter, and also the UCP or the Uniform Customs and Practices for Documentary Credit. So this will be discussed further by the next reporters. So in summary, our international mercantile customs and usage such as Incoterms and the UC they play crucial role in governing sales contracts by providing standard rules and practices for the businesses engaged in international trade. So they help to ensure the clarity, the consistency, and the efficiency in commercial transactions on a global scale. So we have here the other legal sources. So the model contracts and the general principles of the contract law and other sources of law, which are also becoming increasingly important in governing international commercial contracts in the general and sales contracts in particular, having a legal effect similar to international mercantile customs and usage. When we say model contracts, it is necessary to distinguish a model contract drafted by professional association from one provided to the parties by an independent organization. So, ang model contracts are the standard contract templates or forms developed by the professional association or independent organization para makaprovide some guidance and uniformity in specific types of transactions. So, it is served as the valuable tools for parties involved in international sales contract by providing standardized terms and clauses kung sa diin gina-reduce niya ang negotiation time and also legal uncertainties. So, professional association of many sectors have developed model contracts such as ang model contract on the sales of grain or the CAFTA contracts, and the sales of oil or the FOSFA contracts, and the sales of coffee, cocoa, or cotton. So we have here general principles of contract law. So they have been usually the principles extracted from international businesses practices recognized and applied by traders in their international contracts transactions. So they have considered popular. So they have been included principles of free contract, cooperations, good faith, and precaution. So most of these principles have been inserted uniformity have been also inserted uniformly into national laws. So ang general laws of contract, it encompasses the fundamental legal principles. So diin gina-derive siya from international business practices and recognized as common principles across different system. different legal system. So these contracts are often incorporated into national laws and international convention kung sa din it provides foundation for interpreting and enforcing contracts. So the importance of model contracts and the general principles of contracts, so they play a significant role in governing international commercial contracts. So then it includes here the sales of contracts. They provide parties with guidance and common framework for negotiating, drafting, and executing contracts, contributing to legal certainty, fairness, and efficiency in international trade.